It's a great honor for me to take part in this meeting. Thank you, Sarah. Thank you, Peggy, for the invitation. What I would like to talk about is the Israeli system of road accidents victim compensation. It's a system that we have in Israel since 1975, which is quite unique. It is a no-fault system. Any person injured in a road accident in which a motor vehicle was involved is entitled to compensation without the need to prove liability. The question, who caused the accident, is not relevant. Now, the interesting point is that the whole system is based on the private insurance companies and not on the national welfare institutes. The Israeli law forbids driving a motor vehicle without having a valid insurance policy. Violation of the law in this respect is a criminal offense. You have to purchase it, the policy, from any private insurance company. Now, this mandatory insurance covers not only the driver's bodily injuries, but also the passengers in the vehicle who were injured, and pedestrians who may have been hit by the vehicle. So as a matter of fact, almost everybody who was injured in an accident is entitled to compensation. Even, for example, a drunk driver is entitled. The road accident compensation law does not apply in several cases. When someone causes an accident deliberately, as the example Sarah gave us from Sorrento, I believe, or when the injured driver stole the vehicle, or when the vehicle was used for perpetrating a criminal offense, or when the driver had no valid insurance policy. Now, the validity of the insurance depends on having a driving license. In the case that the driver had no valid insurance policy, the passengers and pedestrians who were injured, they get compensation from a special fund, but the driver himself is not entitled to any compensation under the law. And when we talk about compensation that the injured person is entitled to, we talk about a full compensation for his bodily injuries, with 3 exceptions. We also have some exceptions by law. The first is, when you calculate his loss of earnings, you don't take in account any earnings above 3 times the average wage. The average salary in Israel is about 2,000 euros a month. So the maximum earnings that you take in account are about 6,000 euros per month. This, of course, has a negative result for those who earn more than 3 times the average, but the whole idea was to make it a social law and to pay compensation to any road accident victim. The second exception relates to the income tax, and there's a difference. In cases under the general tort law, the loss of earnings calculation is based on the gross salary. Here, in the case of road accidents, there is a reduction of income tax from the earnings up to a maximum of 25%. Now, in respect of non-monetary compensation, such as pain and suffering, there is also a limit of compensation. As you well know, pain and suffering are always hard to calculate, and many disputes are in this field. In order to simplify the system, the law provides a formula for calculating these items. The formula is based on the permanent invalidity percentage of the injured, the number of days he was hospitalized, and on his age at the time of the accident. Now, there is a common list of invalidities. Each one of them gets its own percentage of invalidity. For example, the tip of the finger gets 5% invalidity, and the loss of one eye, for example, is 30%, and so on. These are the three limits of compensation, and this balance arrangement ensures compensation for each and every person injured in a car accident on the one hand, okay, and on the other hand, moderately limits the amount of compensation. Once the injured person has a cause of action under the road accident compensation law, this is his unique way of action. He cannot file a claim under the general tort law for his bodily injuries. Now, as I mentioned before, the interesting part is that although it is a mandatory insurance, it is based on the private insurance companies. Furthermore, although we deal with private companies, the whole field of this insurance is governed and supervised. This is necessary in order to prevent insurance companies from taking advantage of the insured persons who in fact were forced to buy the insurance, to purchase the insurance. The legislator dictates the policies which have to meet the following standards. First, the insurance policy ensures all the persons injured in a road accident in which the vehicle was involved for full compensation in respect of all bodily injuries sustained, with the exceptions I mentioned before. Second, the Commissioner of Insurance supervises the insurance tariffs and the terms and conditions of the insurance according to a uniform policy. The Commissioner can also intervene in disputes that occur, and actually he safeguards the insured person's interests. Third, the legislator prohibits the insurance companies from limiting the insurance coverage according to anything. They cannot limit it according to the conditions of the motor vehicle, according to the age, according to the driving experience, mental or physical conditions, and so on. The insurance company can either sell an insurance policy to the customer or refuse to sell it. Now, what happens with non-profitable candidates? In order to implement insurance coverage also to those who are not profitable and the insurance companies have no interest in insuring them, the legislator set up the pool, which is obliged to insure each and every motor vehicle user who did not succeed in obtaining an insurance policy with a private insurance company, such as motorcyclists. Now, till 2006, the insurance tariffs had a fixed price. In 2006, the motorized vehicle insurance market was reformed. Differential tariffs were set, and very high premiums were imposed on owners of two-wheeled vehicles. Strong objections were raised throughout the country, and those young people refused to purchase insurance coverage. The legislator was forced to intervene, and in order to make them more profitable for the insurance companies, he determined that in an accident involving two-wheel vehicle with a motor vehicle, the motor vehicle insurers will pay the two-wheel insurers 75% of the compensation with which the two-wheel insurers were debited. Okay? This, of course, enabled the insurance companies to sell policies at more reasonable price to motorcyclists. The mandatory insurance has proven to be very profitable for the insurance companies, and there are several reasons for that. First, in many cases, when you sell a mandatory insurance, you get in contact with a person that is usually not interested in insurance at all. He lives very well without insurance. Now he is forced to get an insurance. His standards may change. You can sell him a health policy as well. Second example. When, for example, an insurance agent approaches a factory and offers an all-risk insurance coverage for all the assets, he also sells mandatory insurance policies for all vehicles owned by the same factory. Two policies for the same factory. Third, by its nature, we all know that there is a time gap between receipt of the premium from the insured and the payment of the insurance benefits. In this interval, the money is held by the insurance companies and invested in the capital market. As a result, the profit of the insurance companies from the mandatory insurance in the first half of 2013, we don't have anything more relevant, amounted to about 104 million euros, and as a matter of fact, 60% of the profit of the insurance companies in elementary insurance derived from mandatory vehicle insurance. Now, take into account that these nice profits were calculated after those insurance companies had to transfer about 8 million euros to Carnit in the same period. Who is Carnit? Carnit is a fund which was established in order to compensate injured persons that cannot get compensation from an insurance company under the law because of several reasons. For example, those who were injured following a hit and car accident, or persons injured by a stolen vehicle, or injured by a vehicle which was not insured, as well as cases in which the insurance company is in liquidation. This is the purpose of Carnit. For almost 40 years, we have had this system that proved itself quite efficient. As a plaintiff's representative, I can testify that it is relatively simple to handle a road accident claim, relatively simple to handle a road accident claim in comparison to claims under the general tort law. The questions raised are mainly in respect of the application of the law. The question raised are mainly in respect of the scope of the injury, but legal question in respect of the application of the law also raised from time to time. For example, the law relates to motorized vehicles. What about electric bicycles? Is it a motorized vehicle? What about electric buggy or motor engineer equipment? Does the law apply to these? Another example is, what is a road accident? Only regular accident when two vehicles impact, or let's say when the person who was injured while entering the vehicle, or pushing the vehicle, towing it, or loading or unloading the vehicle, do these fall under the definition of a road accident? In spite of the above-mentioned disputes, road accident cases are quite easy to handle. As previously stated, there is no need to prove liability, which of course makes it simpler for the claimant. Furthermore, various mechanisms exist which make the proceedings simple and easy. For example, when a plaintiff files a claim in respect of bodily injuries according to the general tort law, he is obliged to attach to the claim an expert medical opinion. Such requirement does not apply in respect of the road accident compensation law. The court appoints an expert on its behalf in the medical areas which appear to be relevant to the alleged injuries. There is also a mechanism that provides the injured person with some money in advance for his basic needs after the accident, and these sums are reduced from the total compensation. And finally, sadly, but finally, the law limits the fees of lawyers who represent plaintiffs in claims according to the road accident compensation law. Our fees are between 8 and 13%. Don't cry. It's okay. It's enough. Our fees are between 8 and 13%, which is approximately half of our fees in actions under the general tort law. So this is it. I can only recommend to imply this system in your countries, and thank you very much for listening so patiently.